if it's all right with everybody, maybe we'll give them, the other members of the committee, one more minute to sign in.
Member Funk, do you mind turning on your camera if available? Thank you. Hello.
I'll just wait for it to be 6:01.
Sure, we do have quorum.
Okay, so we'll get going here. This is a regular meeting of the Planning Advisory Committee for the 21st of February of 2023. As we gather, we recognize that we're on Treaty 3 lands, which are steeped in rich Indigenous history and home to many First Nations and Métis people today. We continue to be thankful for the partnerships with Indigenous people. We give thanks for the many blessings we enjoy in the city of Kenora. We seek wisdom in our minds, clearness in our thinking, truth in our speaking, and always love in our hearts. Let these principles guide us in our decision making. Okay, so prior to calling the meeting to order, there are just a few housekeeping items. So please ensure that your microphone is on mute, and be mindful that what is visible to the public and behind you. Please note this meeting is being recorded, and by continuing to be in the meeting, you are consenting to be recorded. Tap Leave Meeting to opt out and exit the session. When it is time for public comments, I will address the participant by name that was used to register for this virtual Planning Advisory Committee meeting. Once your name has been called, please then unmute your microphone or your telephone. All persons addressing the committee shall state their full name and mailing address and must direct their comments through myself, the chair. Decisions will be mailed or emails to the applicant, agent, and to all other interested parties who have provided their mailing address and/or email address to the Secretary Treasurer. Recent changes made by the Province of Ontario, Bill 23, More Homes Built Faster Act, have changed who has the right to appeal decisions made by the Planning Advisory Committee. Other than the applicant, only a specified person or a public body as defined in Section 1(1) of the Planning Act has the ability to appeal the decision to the Ontario Land Tribunal. The notice of appeal for minor variance applications must be filed with the Secretary Treasurer within 20 days of the making of the decision. The notice of appeal for a land division application must be filed with the Secretary Treasurer within 20 days of the mailing of the notice. The Secretary Treasurer for the Kenora Planning Advisory Committee is Melissa Shaw. The City Planner is Kevin Sumner. Albrecht Marginet is the Associate Planner. All right, so I'm going to call the meeting to order at 6:03. Are there any additions to the agenda?
We do. We have one amendment and one addition. Acknowledging that applications D10-2213 and D10-2214 have been incorrectly filed under old business. Madam Chair, we ask that you amend the agenda to reflect these applications to be heard under considerations of applications for land division. The applications were deferred in advance of a public meeting and are not considered old business. The applicant, Mr. Magnuson, has been advised of this request, and so we ask that you amend the agenda as such. In addition, there's also a request for a deputation on behalf of the Black Sturgeon Lake Property Owners Association, and we have with us here tonight the President, Mr. George Turpey.
Okay, so I understand that we should be certainly putting the two land division applications under consent. And I think it is important to hear from the Black Sturgeon Property Owners Association on a going forward basis, we understand their basic mission. And so, Mr. Turpey, we welcome you, and I ask that you do keep to a 5-minute presentation. And I also would recommend that you make the same presentation to council at another time.
Thank you. Is it my turn to go then now?
It is.
Thank you, Madam Chair, for giving us the opportunity to speak today. I did want to, as you may know, we were originally scheduled to speak on a minor variance application, which was in the end canceled or withdrawn. But I thought it would be good to have a chance to talk to the Planning Advisory Committee to let you know who Black Sturgeon Lake Property Owners Association is and what we do. The BSL POA, the letters for Black Sturgeon Lake Property Owners Association, has been founded for all property owners living on Black Sturgeon Lake interested in an organization to work for their common good, the maintenance and the enhancement of quality of life on the lake for both seasonal and permanent residents through careful attention to matters such as water quality, shoreline development, boating, and swimming safety. The BSL POA represents more than 150 properties on the lake, and in fact, that's grown quite a bit since the beginning of 2023. The purpose of our association is to promote and foster a sense of community, friendship, and mutual respect amongst property owners of Black Sturgeon Lake, to provide a focal point for addressing issues that may arise concerning the property owners of Black Sturgeon Lake, to provide a forum for the exchange of information, concerns, communications between members of BSL POA, to promote, maintain, and to promote maintaining the pristine nature of the water quality and surrounding shorelines of Black Sturgeon Lake, and to communicate with the media and general public of concerning issues and interest of interest to the members. One of our goals, or one of the things that we would love to see, is the protection provided to the Black Sturgeon Lake restricted development area within the city's official plan, expanded to all areas of the lake. We were, of course, aware of a recent application to allow for expanded docks on a property of the lake for the future purpose of creating a marina, specifically one for float planes. That created a lot of concern amongst members of the association. We were very concerned about the impact that this could have on the lake, including water quality and the suitability of such a business in a residential neighborhood.
Excuse me,
And as such,
Mr. Turpie, I would ask that you keep it generic, please, in case there is an application that comes forward to this committee. It's not fair that there's not an agent for the applicant to respond to what you're speaking to. So if you wouldn't mind just keeping it generic, please.
certainly, I'm sorry if I've crossed any line. That was certainly not my intent. I was just using that as an example to describe what our area is concerned about. Through looking at that, and hopefully this is still generic, we were concerned about some of the apparent discrepancies between the official plan and zoning bylaws. And we are keen to see draft revisions to the official plan that are expected this year and how the city will respond to that with the bylaws. And I know that's not the PAC that would take care of this. And Madam Chair, you suggested that I speak to council. And so maybe that's something I should try to figure out how to do that. So I don't really have too much more comments. I wanted to share with you what we are, who we represent on the lake, and why we would have concerns about. We are not opposed to development on the lake. Certainly within the bylaws, we are not interested in. I'm not interested in any kind of, I don't know what the right words are, but picking fights with any members of the community over any areas, any developments that might be planned. But I am interested in looking out for and protecting the best interests of the lake and the residents of the lake. And so that's what Black Sturgeon Lake Property Owners Association is all about. So I would like you to thank you for the opportunity to spend a couple of minutes telling your committee who we are.
Well, and I thank you. And Ms. Shaw, would you mind forwarding information to Mr. Turpie about how he can speak with council?
Certainly, we will do that.
Thank you.
Thank you very much. I think that means I can leave now, and that's okay.
You're certainly welcome to stay if you wish, but you are welcome to leave if you wish to do that as well.
I will stay around for a minute or two, but thank you very much for your time today.
Thank you. All right. So any declaration of interest by a member for this meeting or at a meeting in which a member was not present?
I have received none, Madam Chair.
All right, thank you. And the next is the approval of minutes for the meeting held on January 17th of 2023. There were some initial changes made after I read the draft, and so Albrecht did make those changes. If there is anybody who has anything else.
Were those just grammatical and error or grammatical in nature, Madam Chair?
It's really, yes, there, it was
Okay.
not intent.
Okay. So we will look for those to be carried as approved.
We have a mover, please. Andrea, and a seconder. Carrick. And all in favor? Thank you. They can be distributed as amended.
Thank you.
All right, any correspondence relating to applications before the committee?
Information that we wish to have captured within the meeting minutes is that application for minor variance file D13-2214, which was in relation to 351 Peterson Road, made on behalf of MCL Holding Inc., was withdrawn by the applicant. So we do just want that identified in the minutes as part of the public record. Notice of the withdrawal was sent by the agent and received by the city of Kenora on February 16th, 2023. This was communicated with all interested parties, including PAC and members of council.
Thank you. Any other correspondence?
We have received none.
Okay, any adjournment requests?
I have not received any as of today's date.
All right, so there are no applications for minor variance, so we'll move on to consideration of applications for land division. And so we will go with D10-2213 Magnuson for a lot addition. Mr. Magnuson, would you like to present your application?
So what I'm applying for is to divide my property on Peterson Road into 2 lots and add a 11-meter wide strip of Mr. Burbank's property to give me the required frontage on Peterson Drive. The proposed action would I think fit with the objectives of the city of Kenora in that it increases housing density, would provide for 1 additional residential property, would increase the Kenora tax base. The province of Ontario has suggested an archaeological study, and my understanding of their position is they are doing so because the property is within 300 meters of other archaeological sites. That is factually incorrect. It's more than 350 meters from the nearest archaeological identified site. My preference would be that such a study not be required. I need to get this division done before I sell my property. I'd like to get on with that. If an archaeological study is required, basically that puts me out of the spring sale period in 2023 into probably into 2024. And from the city's point of view, the increase in tax base is probably similarly deferred for most of the year. It's hard to see that the property has any archaeological value because it is relatively steep, not as steep as some of the other lots on Peterson Drive, but quite steep. And most archaeological sites in the area are on low, relatively level property close to the water, where somebody traveling on the water would likely camp. And this site is simply not where somebody would camp. If there's any other information the committee would need, I'd be happy to offer it, but that would be all I have to offer at this point.
Thank you. We'll ask Mr. Sumner, city planner, to provide his report, please.
Yes, certainly. And I'll go into more length on this original report or this first report and a little bit less on the second. There's a lot of quite similar information, but and a lot of the comments that were provided were in regards to both applications, but I'll clearly differentiate between them and when I get to my recommendation. So hopefully this will make sense. As already mentioned, this application is to sever a small portion of or about 0.12 hectares, or about 1/8 of a hectare from the one property at 211A Peterson Drive, and to add that same portion of property to 211 Peterson Drive. There would be no creation of new lots as a result of this proposed severance. This property is located on the north shore of the Winnipeg River, approximately 500 meters east of the Darlington Bridge and 450 meters northwest of Tunnel Island. The property is largely tree covered, with an existing dwelling and accessory structure being located near the southwest corner of the property. The property has direct road access from Peterson Drive and is serviced with private water from the river and a septic field. The applicants own the neighboring property to the south, which also fronts on the Winnipeg River. Access to that property is currently provided via an easement over the subject property. The applicant is proposing to create a new lot on the property, which we'll be hearing about in a few minutes, and is proposing to add the severed parcel to their property so that this new lot on the eastern portion of their property will comply with our policy requiring that new lots have permanent frontage on a public road where such access can be reasonably provided. Neighboring properties along the shoreline of Peterson Drive primarily contain residential uses or remain undeveloped. Turning to consistency with legislative policy and city directives, first of all, the provincial policy statement, which promotes managing and directing land use to achieve efficient and resilient development and land use patterns. The PPS permits residential development, including lot creation that is locally appropriate, and states that development that is compatible with the rural landscape and can be sustained by rural service levels should be promoted. When a development proposal is within an area considered to have archaeological potential, the city shall require an applicant to undertake a stage 1 archaeological assessment of the lands in accordance with the requirements of the Ministry of Tourism, Culture and Sport to determine the nature and extent of the resources on the site. The study must be conducted by an archaeologist licensed under the Ontario Heritage Act as a condition of any development proposal and submitted to the city and to the Ministry of Tourism, Culture and Sport. The PPS states that planning authorities shall not permit development and site alteration on lands containing archaeological resources or areas of archaeological potential unless significant archaeological resources have been conserved, and planning authorities are to engage with Indigenous communities and consider their interests when identifying, protecting, and managing cultural heritage and archaeological resources. Turning then to the City of Kenora official plan. Land use designation here is rural area, which provides for a variety of uses, including agriculture, residential, industrial, commercial, recreational, tourism, and open space uses. Adjacent properties are also designated as rural area. Residential development in the rural area is restricted to single detached dwellings on relatively large lots serviced by private water and sewage. Development proposals are to be limited in scale and not detract from the planned role and function of the settlement area, and preserve rural character and the scenic quality of the rural landscape, avoiding densities more appropriately found in the settlement area. An area of the river adjacent to the subject property, visible on the map in my report as the hatched area that's on the map labeled as figure 2, has been identified as a fish spawning and nursery area. Fisheries assessment and environmental impact study must be completed by a qualified professional when development or site alteration is proposed on a shoreline within 120 meters of a fish spawning and nursery area. The parcel being severed in this case is on the opposite side of the lot, approximately 160 meters from the fish spawning area, and doesn't directly involve shoreline development. This property has been identified by 2 First Nations and the Ministry of Citizenship and Multiculturalism as having cultural and archaeological significance. The official plan requires that where a development proposal or site alteration is within an area considered to have archaeological potential, the city must require the applicant to undertake a stage 1 archaeological assessment of the lands in accordance with the requirements of the Ministry of Tourism, Culture and Sport to determine the nature and extent of the resources on the site. And finally, the zoning bylaw. The property is zoned RR, or rural residential zone. Lots in this zone must have a minimum lot frontage of 61 meters and a minimum lot area of 1 hectare. Adjacent properties along the shoreline are also zoned RR, while properties to the north on the other side of Peterson Drive are zoned as RU, or rural zone. An area of the river west of the property corresponding with that fish nursery area is zoned as EP, Environmental Protection Zone. Now, turning to interdepartmental and agency circulation, and as I mentioned, these are when we circulated this in the next application, a lot of the comments we received back were in regards to both, and some didn't quite clearly identify. So for this and the next report, I've included the full list of comments that we received. So I'll go into them all with this report, even though some may be more applicable to the next application. So first of all, Enbridge Gas indicated that they do not have service lines running within the area, or they do have service lines running within the area, which may or not be affected by the proposed severance. And it should the proposed severance impact these services, it may be necessary to contact Enbridge regarding their concerns. But you will note that the map provided by Enbridge notes identifies that their lines are located further west on the other side of the small little inlet there on completely on separate properties, and there are no Enbridge lines that are directly on either of the properties being considered for consent applications tonight. Kenora Roads Department comment that they have no concerns, but a new entrance permit will be required. And that'd be for the new lot and frontage. And the Ministry of Citizenship and Multiculturalism commented that with the information provided to date, the subject property meets the provincial criteria for archaeological potential. In order for the application to be consistent with the provincial policy statement, it would be appropriate to request that an archaeological assessment be undertaken for the subject property, both the retained and severed lands. And that again refers more directly to the next application, and submitted as part of the application. An archaeological assessment will confirm whether archaeological resources may be on the property and the next steps to ensure the future conservation. But again, the municipality is the approval authority and responsible to trigger any studies and be accountable for its decision. Please note that archaeological concerns have not been addressed until reports have been entered into the Ontario Public Registry of Archaeological Reports, where those reports recommend that 1, the archaeological assessment of the project area is complete, and 2, all archaeological sites identified by the assessment are either of no further cultural heritage value or interest per section 48.3 of the Ontario Heritage Act, or that mitigation of impacts has been accomplished through excavation or an avoidance and protection strategy. The Ministry of Natural Resources and Forestry comment that their values indicate there is walleye spawning habitat immediately east of this frontage and a deer wintering habitat encompassing both of the lots. They aren't recommending additional studies at this time. However, they do recommend that the property owners be encouraged to seek professional advice on the placement of any future docks in order to minimize impacts on fish habitat. And Nisatchua Anishinaabe Nation provide the comment that their initial review of the application suggests that the proposed activity is within the vicinity of traditional use assets and could have impact on their credibly asserted inherent and treaty rights. Traditional assets identified include, but are not necessarily limited to berry picking, fishing camps, travel and access routes, and culturally significant sites. They are objecting to the proposed activity because of the potential impacts the proposed activity represents to their inherent and treaty rights, their ability to exercise their culture and way of life, and because of their growing concern over the cumulative impacts of unfettered development in their territory. As Treaty 3 nations, they are guided and bound to their sacred law, the Manitowoc and Ekatawagan, which requires consultation with their elders and knowledge keepers to assess potential impacts, identify any required mitigation efforts, and establish appropriate ceremonial protocols. Once this consultation has been conducted, they will reevaluate their position on this file and then consider whether consent can be granted. They remind the Crown of its obligations under Section 35 of the Constitution Act 1982 to protect and respect their inherent and treaty rights and the principle of free, prior, and informed consent outlined in the United Nations Declaration on the Rights of Indigenous Peoples. The Northwestern Health Unit commented that they have started the application process and have contacted the owners. They will not be able to conduct a proper site inspection until the snow is gone and some of the frost has left the soils. They reserve the right to comment once conditions permit. TC Energy, TransCanada Pipelines, has 3 high-pressure natural gas pipelines contained within an easement or right-of-way north of Peterson Drive. TCPL's pipelines and related facilities are subject to the jurisdiction of the Canada Energy Regulator, formerly the National Energy Board. As such, certain activities must comply with the Canadian Energy Regulators Act and associated regulations. The Act and the regulations noted can be accessed from the CER's website. At the request of TC Energy, the regulatory and development requirements and TC Energy's work safety handbook have been forwarded to the applicant in the event of any future activity in proximity to the pipelines. And then Washish-Kanigan Nation has commented that they are their initial review of the application suggests that the proposed activity is within the vicinity of traditional land assets and could have impacts on their credibly asserted inherent and treaty rights. Traditional assets identified include, but are not necessarily limited to, fishing and culturally significant sites. They are objecting to the proposed activity based on the potential impacts the proposed activity represents to the inherent and treaty rights, their ability to exercise their culture and way of life, and because of their growing concerns over the cumulative impacts of unfettered development in their territory. As Treaty 3 nations, they are guided and bound to their sacred law, the Inakatagowan, which requires consultation with their elders and knowledge keepers to assess potential impacts, identify any required mitigation efforts, and establish appropriate ceremonial protocols. Once this consultation has been conducted, they will reevaluate their position on the file and then consider whether consent can be granted. They remind the Crown of its obligations under Section 35 of the Constitution Act 1982 to protect and respect their inherent and treaty rights and the principle of free, prior, and informed consent outlined in the United Nations Declaration on the Right of Indigenous Peoples. Turning now to public comments, circulation of the notice of complete application and hearing for consent to sever was completed in accordance with Section 53 of the Planning Act. As of the date of the report and since, no public comments have been received. And then turning to my evaluation. So if approved, the proposed new lot will provide direct access to Peterson Drive for the applicant's property to the south. No new lots are being created, and the lot addition will not create an opportunity for new development beyond what is currently permitted on both properties. The Ministry of Natural Resources and Forestry has identified that there is a deer wintering area encompassing both of the lots, but have recommended that no studies be required at this time. The Saskatchewan Nation and Washish-Kanigan Nation have objected to the application, identifying that this property is in the vicinity of traditional land use assets, including but not necessarily limited to fishing and culturally significant sites. This is supported in comments received from the Ministry of Citizenship and Multiculturalism, which has identified that the property meets the provincial criteria for archaeological potential. Both the provincial policy statement and the official plan state that such assessments are required prior to development or site alteration. As the proposed lot addition, though, will not create any opportunities for development that is not already present on these two properties, an archaeological assessment is not being recommended in regards to this consent for lot addition. Nishachuan and Anishinaabe Nation and Washish-Kanigan Nation have included comments regarding Section 35 of the Constitution Act 1982. This act and what is commonly referred to as duty to consult are generally applicable to federal and provincial crown developments. Municipalities are not bound by this constitutional duty in regulating development of privately owned land. What the City of Kenora does do is ensure that our neighboring First Nations are informed of the public consultation process and provided with the opportunity to provide formal comment with respect to applications as has been done with this application. So I include with my report the legislative framework for consent approval, which I won't repeat or I won't read in detail this time. And I'll move forward then to my recommendation, which is that application D10-22-13 for consent for lot addition on property located at 211A Peterson Drive, legally described as PIN 42161-0577, City of Kenora, be approved and provisional consent be granted, subject to the following. One, that the originally executed transfer/deed of land form, a duplicate original, and one photocopy for city records be provided for each parcel. Two, that a schedule to the transfer/deed of land form on which is set out the entire legal description of the pins in question and containing the names of the parties indicated on page 1 of the transfer/deed of land form is to be provided for each parcel. Three, that the lands to be transferred for lot addition be surveyed and described on a reference plan and that a draft is provided to the planning department for pre-approval. Four, that the newly created lot be consolidated on title with the adjacent lot identified as pin 42161-0178, and if recommended on solicitor review, that a merger agreement be entered into. Five, that 3 original copies and 1 PDF copy of the reference plan of survey bearing the land registry office registration number and signatures as evidence of deposit therein, and illustrating the parts to which the consent approval relates, which must show in general the same area and dimensions as the sketch forming part of the application be provided. 6, that the payment of outstanding taxes, including penalties and interest, and any local improvement charges if applicable, shall be paid to the city of Kenora. 7, that prior to endorsement of the deeds, that the secretary treasurer shall receive a letter from the owner or owner's agent/solicitor confirming that conditions number 1 through number 6 have been fulfilled. Clearance from the city of Kenora and external agencies as required are to be included. And finally, 8, that all costs associated with surveys, legal fees, and matters related to the application are the responsibility of the developer/applicant. I note for the record that section 5341 and 5343 of the Planning Act apply to this application. And with that, I conclude this report.
Thanks, Kevin. So Mr. Magnuson, do you have anything else that you'd like to add that came out of that report?
The only comment would be with respect to the health unit. I did walk through the property last fall with a representative of the health unit, and he verbally was of the opinion that that there was no problem from their point of view. So I don't quite understand the comment that they have further work to do, but that's a minor issue.
Thank you. And so if you know, if anything further is required, then it would become a condition of approval if something wasn't submitted in advance. Okay, thank you. So committee members, anybody have any questions or comments? Okay, no discussion. I have one comment, and I think that the province has indicated that a requirement is that there is a required archaeological study, and so in my opinion, I think that Mr. Sumner's recommendation is for deferral until that's received and approved then by the province is in line. Yes, Kevin, do you have a comment?
The archaeological assessment is being recommended in the next report where in regards to the lot creation.
Right.
Yeah.
Yeah. Sorry about that, everybody. So there are no comments or anything about the lot addition. Jay, do you have a question?
Yeah. Just to clarify to me whether I know these are related files, but if this one is approved and the other one is not, I'm just speaking hypothetically. Would that be a benefit to the landowner? If this one is approved, yet we don't know what will happen with the second.
Mr. Magnuson, would you like to respond to that?
I think if ultimately 13 is approved and 14 is not approved, we probably would not go ahead with 13. But I haven't discussed that with Mr. Burbank.
Thank you.
Thank you.
Ms. Shaw, could you just explain then how it works if there is a provisional approval, the length of time that the applicant would have to meet conditions, so that there are conditions for the next application, as an example?
Certainly. So under section 41 of the plan, or section 5041, you do have 2 years to complete those conditions that are imposed upon you by the committee. The city planner through the planning report has identified, I believe there's 8 conditions that would apply to this application. And so those would be required to be completed within that 2-year time period. So this evening, if you are given provisional approval, it would be to enable you to start to satisfy those conditions within that 2-year time frame, upon which time the city will endorse a consent by way of a stamp.
And then just further, if they decide not to go forward, then and don't meet the conditions, then nothing
Certainly,
happens.
then it would just lapse. So if there's an expiration after 2 years and those conditions are not met, then the consent would simply just lapse.
Okay, Andrea, you have a comment?
So he's not applying for a building permit, and a lot of these things seem to be contingent on like a building permit, like development of the property. And if it's subdivided and we're not dealing with the building permit yet, couldn't that just be deferred to the new owner, as Mr. Magnuson suggested? He's hoping to sell it as a developable land, but we could just have it as these conditions. And
Is that a question through the chair to the city planner?
Yes, please.
Kevin?
Yes, the provincial and official plan policies are specific to planning approvals. Once a lot is created through the planning approvals, the building permit process is not a planning process. There is applicable law, but I can't, I'm not going to speak for our building officials. Generally, the approach is that where a planning approval would create the opportunity for development, so there's a right, once a lot is created, to apply for to put in the case of a rural residential lot, a dwelling or a permitted use on that property as soon as that lot is created. So rather than create a new lot before the archaeological assessment, it's generally would be recommended in a situation like this that the archaeological assessment be completed first, and then if there's no concerns or archaeological concerns, then the law can proceed with creation and permits can be issued.
Thank you. Just so everybody else knows, Ms. Campbell is going off and on because she's having audio issues. So it's she gets a constant audio when you can't see her when the video's off. So Andrea, are you satisfied with that answer then?
yes, I am.
Okay, thank you. So, Ms. Shaw, would you read the resolution, please, for the decision?
Certainly. As per the planning report, that application D10-2213 for consent lot addition on property located at 211A Peterson Drive, legally described as PIN 42161-0577, City of Kenora, be approved, and that subsection 53 of the Planning Act applies to any subsequent conveyance of or transactions involving the parcel of land that is subject of this consent, and that provisional consent be granted, subject to the conditions outlined within the planning report.
Do I have a mover for that resolution? Renee? And a seconder, please. Jay? And all in favor? Okay, you've got everybody opposed. All right, and that motion is carried.
Thank you. Mr. Burbank as owner and Mr. Magnuson as agent, you have received provisional approval here this evening. There are appeal limitations to this notice of decision, which will be sent out by Thursday this week. So the applicant, the minister, or specified bodies, or any public body, or specified person, sorry, or any public body no later than 20 days after the notice of decision, appeal the decision to myself, the Secretary Treasurer. I will outline that within the notice of decision, but that would take us to an appeal date of March 15th. Mr. Burbank and Mr. Magnuson, again, you will have 2 years to complete those conditions that are outlined within the planning report, and we can certainly carry on those discussions after this meeting to discuss how you can satisfy those conditions to meet consent. Okay.
Thank you. All right, and so then the next file is also Magnuson lot creation D10 2214. Mr. Magnuson, would you like to add anything to what you've already spoken to, or would you like Mr. Sumner to provide his report?
I have no further comments. Thank you.
Mr. Sumner?
Yes, so this application is for the next, affects the property to the south of the one covered in the previous application, this being for 211 Peterson Drive. And this application is to create, as I mentioned previously, one new lot in the rural residential zone. So the existing conditions section of my report remains the same. And as does the provincial policy statement, the official plan, and the zoning bylaw sections of the report. So I'm not going to repeat those sections, other than I will note that just when you're in the case of talking about proximity to the designated features. So if we under the official plan, when we talk about the fish spawning area, this property here is even further away from the fish spawning area than was the previous application, and though there is shoreline involved, it exceeds the 125-meter limit within which special studies would need to be completed. And otherwise, I believe everything else is the same in those sections of the bylaw. And also the interdepartmental and agency circulation comments, those all the comments included under that sections are the same ones which I already previously read into the record when delivering the early report. Public comments, as with the previous report, there's the circulation of the notice of the application and hearing for consent to sever was completed in accordance with section 53 of the Planning Act. And like with the previous report, there was no public comments received as of the date of the report or since. Now, where I go off on a bit of a tangent with this report is in regards to the evaluation. So I'm going to go into that section of this report in depth. So if approved by this application, will result in a proposed new lot that will allow for development of a new dwelling site. The application is compliant with the regulations of the RR zone of the zoning bylaw with regards to such things as lot size, lot area, and lot frontage. The frontage requirement being met on the river, plus with the addition of the lot through the previously approved consent for lot addition. The Ministry of Natural Resources and Forestry has identified there is walleye spawning habitat immediately east of this frontage and a deer wintering area encompassing both the lots. But I've recommended, as with the previous one, or in conjunction with, in regards to both of the applications, that no studies be required. Nisatchewin, Anishinaabe Nation, and Washishkinagam Nation have objected to the application, identifying that the property is in the vicinity of traditional land use assets, including but not limited to fishing and culturally significant sites. This is supported again by comments provided by the Ministry of Citizenship and Multiculturalism, which has identified that the property meets the provincial criteria for archaeological potential. In light of these concerns with this application, it is recommended that a stage 1 archaeological assessment be completed in accordance with requirements of the Ministry of Tourism, Culture and Sport to determine the nature and extent of any resources that may be on the site. So as an aside, we're talking about potential here. The fact is that it meets certain criteria where there's a concern that there may be potential. We don't know for certain that that there is any archaeological resources or cultural resources to be found on the site, and that would be the purpose of the stage 1 archaeological assessment by a qualified archaeologist to determine if there is in fact anything on the property. Nishachuan, Anishinaabe Nation, and Washishkanagam Nation have included comments regarding Section 35 of the Constitution Act, 1982. This act and what is commonly referred to as duty to consult are generally applicable to federal and provincial crown developments, as I noted in my previous report. And as also previously noted, municipalities are not bound by this constitutional duty in regulating development of privately owned land. And what we've done is ensure that neighboring First Nations are informed of the consultation process and provided with opportunity to provide the comments which they have. I am therefore recommending that the committee that approval of the consent application be deferred until such time as the archaeological assessment has been completed, so that the findings can be considered in the committee's decision. So what that would mean would be that once the phase 1 report is completed, that then the application, that information could be brought along back to the committee along with the original application, and a recommendation could be made, a fully informed recommendation could be made at that time. So my formal recommendation is that application D10-22-14 for consent for lot severance on property located at 211 Peterson Drive, legally described as PIN 42161-0578, City of Kenora, be deferred until such time as a phase 1 archaeological assessment has been completed and the nature and extent of any archaeological resources have been identified.
Thank you. Mr. Magnuson, anything to add? Mr. Magnuson, do you have anything to add?
Yeah, sorry. I would like to publicly recognize that Kevin, Melissa, and Alberic have been incredibly helpful in getting Peter and I through this rather complex process, and I really appreciate that help.
Thanks, that's great. I'm sure they love to hear that. That's great, thank you. All right, committee members, any questions?
Hopefully this is a quick one. This is for the city planner. Do we know with the relatively new subdivision to the east, was an archaeological assessment done at that time?
To the best of my knowledge, one was not completed for that subdivision when it went through. I can't speak to the rationale or what was considered. All the details may have been considered by the city planner who was here at the time, or what I'm not aware of certainly of any archaeological concerns being raised in regards to that subdivision. But unfortunately, it's not unheard of for one application that is in proximity to a resource of concern to perhaps not catch the attention of for someone to miss that that there is a proximity issue.
Thank you.
Anybody else? Andrea?
I also noticed that the subdevelopment next door, the lots are much, much smaller in both water frontage and total area. How come this lot is like the minimum size and it's so much bigger than the one next door?
Well, the existing lot is fairly large. Once it's severed in half, sometimes those long narrow lots can be a little bit, when you're comparing a long narrow lot with a more square lot like this, sometimes there can be some tricks of perspective. Also, I can't say as I looked in detail at when I was looking at the adjacent subdivision, it was with a very narrow lens where I was looking for some information regarding some of the history, but so I can't recall exactly what the zoning requirements would have been on that application, or whether there's any variances applied at the time. Basically, at the time of those lots were created, they would have had to meet the zoning requirements for the zone in place for the property, but that can change over time with new zoning bylaws.
Thank you. Anybody else? Renee?
Yeah, so quick question. The retained lot doesn't look like it would have access to the main road. Can you explain?
Yes, you're correct. It doesn't have any direct access, but there is an easement over the adjacent property to the north that provides access for that lot. And going back to the time that it was created, that would have met with one assumes with the policies that were in place for new lot creation at the time. So when we're dealing with the creation of a new lot like this, we don't concern ourselves with the existing, the residual lot not meeting the requirements for frontage, but for the new lot that's being created, it has to meet with our current policies. So that's why we've insisted on a road frontage for the newly created lot, but the existing one, the existing dwelling is certainly fine to continue via that easement, and it is a legal easement registered across the property. So I don't have concerns with that continuing to be in place. And it's not unheard of for lots in Kenora not to have road frontage if they have water access, but when a road is so conveniently located, we do insist on the policy.
Thank you. Anybody else? Okay, so would you like to read the resolution, please, Ms. Shaw?
Sure. The decision or the recommendation, is that a decision on application D10-2214 for consent lot creation on property located at 211 Peterson Drive, legally described as PIN 42161-0578, City of Kenora, be deferred until such time that a phase 1 archaeological assessment has been completed, received, and deemed acceptable, my apologies, by the City of Kenora City Planner.
Thank you. Do I have a mover for that resolution? Andrea Campbell, and a seconder, please. Renee Robert, thank you. And any discussion? All right, all in favor of the resolution? Thank you. No, there would not be anybody who is not in favor. The motion is carried. Thank you.
So Mr. Magnuson, as Mr. Sumner, the city planner, have pointed out, this will give you or provide you the opportunity to engage a professional to undertake that phase 1 archaeological. At that point, it would then be submitted to the City of Kenora, and upon review and acceptance by the city planner, it will then come back to the Planning Advisory Committee under old business for consideration.
Thank you very much.
Okay.
Thank you. All right. So now we have new business. Under that is the application for zoning bylaw amendment. Sorry, I've got I don't have the right. Oh, I do. So it's D14-2301. Is there anybody here to represent that application? All right, Mr. Sumner, would you like to give your report on that then, please?
Certainly. So we've received this application to change the zoning of the subject property, which is a currently unaddressed property off of Jones Road, from ML or light industrial zone to what would become ML 55 light industrial exception zone, with a permitted site-specific agricultural use being greenhouses. Oh, I think the applicant has just or no, oh, no, sorry, I thought maybe I'd seen somebody pop into the meeting and I was worried it might be the applicant, so sorry, I can continue on. The property owner wishes to amend the zoning to permit the development of the property with a greenhouse. Agricultural uses are not normally permitted in sorry, that should be ML or light industrial zone. That's a typo in my report. My apologies. The subject property was created in 2022 via consent for lot creation and is currently tree covered and undeveloped. There is no indication that it has ever been developed at any time in the past. It has an area of 1.05 hectares and a frontage on Jones Road. No municipal sewer or water service is available in this area. Surrounding properties contain a mixture of light industrial, commercial, and residential uses on lots of various sizes. Jones Road provides an important connection from Highway 17 East to the bypass and eventually becomes Highway 671 to Grassy Narrows. Turning to consistency with legislative policy and city directives. First of all, the provincial policy statement, which the proposed rezoning is consistent with the policies that promote development in rural areas that is compatible with the rural landscape and could be sustained by rural service levels and are appropriate for the infrastructure which is planned or available. Under the City of Kenora official plan, the land use designation of the property is rural area. Policy 4.8 of the plan states that rural areas include a variety of agricultural, residential, industrial, commercial, recreational, tourism, and open space uses, and that these areas may experience limited change over the lifetime of the plan. Under zoning bylaw number 101-2015, the property is currently zoned ML light industrial zone. This zone allows for a wide range of low impact light industrial land uses, as well as complementary commercial uses. The ML zone does not permit agricultural uses such as a greenhouse. Several neighboring properties, including the adjacent property to the west area, are zoned RU rural zone, and agricultural uses are permitted in that zone. Properties zoned RU tend to be larger properties as the minimum lot size in the RU zone is 2 hectares. Areas zoned HC highway commercial zone and RR rural residential zone are also found nearby along the Highway 17 East corridor. The proposed zoning amendment will allow for a greenhouse to be developed on the property while retaining its suitability for future light industrial uses. When we circulated this for interdepartmental and agency circulation, nobody responded with any concerns. In terms of public comments, though I should note that there are a couple of divisions that haven't yet responded and are currently still reviewing the application, though they've identified at this point no concerns when I've taken the opportunity to verbally speak with those circulated. Turning to public comments, so the public meeting is scheduled to be held by council on March 8th. Notice that the application was given in accordance with Section 34 of the Planning Act, whereby it was circulated to property owners within 120 meters. Was published in the municipal memo of the newspaper and circulated to persons and public bodies as legislated. And then also notice also stated the date and time of the Planning Advisory Committee meeting tonight. As of the date of the report, and since no comments have been received from the public, my evaluation is that the proposed site-specific zoning amendment to allow agricultural use of this property is a reasonable solution to allow a use that seems appropriate for the site and the area. The only other option to allow a greenhouse on the property would have been to amend the zoning to RU rural zone, but that zone is intended for properties of 2 hectares or larger and the associated land uses. The provincial policy statement is supportive of uses that are suitable to the rural landscape and are supported by rural service levels, and the official plan is supportive of a variety of uses, including both industrial and agricultural. Therefore, it's my recommendation as the city of planner, it is that the application for zoning amendment, file number D14-23-01, to change the zoning and subject property from ML light industrial zone to ML 55 light industrial exception zone with permitted site-specific agricultural use of a greenhouse, should be approved in lieu of public comments that may yet be received. And just a reminder that the decision of the committee is not a final decision. It is a recommendation to council for their meeting next month. And council will make the final decision with due consideration for the recommendation of the committee.
Thank you. Committee have any questions, comments? All right. So Ms. Shaw, if you wouldn't mind reading that resolution again, please.
Certainly, and I do just want to highlight something Mr. Sumner has already indicated to the committee. So this is a recommendation to council. So council will hold the statutory public meeting on Wednesday, March 8th, and they will consider approval of the zoning bylaw amendment at their regular meeting of council on March 22nd. So the resolution reading that the Planning Advisory Committee recommends that the Council of the Corporation of the City of Kenora approve application for zoning bylaw amendment, file number D14-2301, for subject property located at an unassigned address on Jones Road and in an identified schedule. So again, this resolution will form part of the public record and a report to council. So we do have a map attached to it. The purpose of the zoning bylaw amendment is to change the zoning of the subject property from ML Light Industrial Zone to ML 55, Light Industrial Exception Zone with permitted site-specific use as agriculture. The effect of the site-specific zoning bylaw amendment is to rezone lands to permit the future redevelopment of the property with a greenhouse. The ML Light Industrial Zone allows for a wide range of low-impact light industrial land uses, as well as complementary commercial uses. The proposed zoning amendment will allow for a greenhouse to be developed while retaining its suitability for future light industrial use. The committee has made an evaluation on the application upon its merits against the official plan 2015, the zoning bylaw 101-2015, and the provincial policy statement 2020, and provides a recommendation to council purely based on these matters, whereas the committee may have not had the opportunity to hear internal departments, stakeholder, or public comments in full.
Thank you. Do I have a mover for the resolution? Carrick, and a seconder? Oh, Andrea, thank you. Any discussion? Nope. So the resolution has been adopted, and that'll go forward to council. Right. Okay. So new business, 2023 OCA training.
Yes, certainly. So I did send an email to all members of Planning Advisory Committee. You do have access to updated 2023 OCA training. To be brutally honest, I did try to go in there and see the videos are very much similar to what they were in advance of 2023. So I'm thinking they may have just, has anyone done it yet? May have just,
Yeah.
yeah.
I listened to some of them and they've overdubbed with a woman's voice.
That's the word I was looking for, overdubbed.
So it does seem like they were updated.
Okay, it may be more beneficial for members to simply review the PDFs that are associated with the videos, because that will capture a lot of those Planning Act amendments in text. And so that's something to easily refer back to. So I've downloaded those. If you want, we can put those up on SharePoint for you. If you don't have time to go into that OCA training, the PDFs may just be a better option for you to reflect those changes.
I would really appreciate that because I had difficulty accessing.
Yes, you did. We will do that for you.
Thank you.
Is there still OCA like an AGM with on-site training offered annually?
Yeah, so usually there is spring training. Kevin, you can speak to this if you've seen anything for the spring training. Historically, city has sent members and staff persons to a fall training session. Of course, that is usually dependent on budget. So we will leave that to the city planner and our director to determine the budget and availability to send some members for training, but certainly that has opened back up. So OCA is doing in-person training again. They offered hybrid the last few years, but certainly we will be looking to members in the next, I'd say we would get an announcement soon about when that training will occur. And we will bring that forward to members with any interest to attend an in-person training, or if they have hybrid, perhaps there's an option to have. Yes, Kevin.
Oh, it's sorry, I didn't mean to interrupt, but yeah, I was going to just add that, yeah, I did take advantage of the fall conference this year myself in Peterborough. One thing I did note is that they massively underestimated this last fall conference. Is I think the first full conference post-COVID. It was sold out, I think 2 months in advance. So hopefully they will adjust for the spring conference. I haven't seen anything about it yet, but we will make sure that it is provided to members as soon as we do get information. But on the budget, the budget as it is right now won't support the full committee attending the training, the conference this year. If there is more demand than there is ability to fund attendance for this year's conference, we'll have to come up with some solution to. What's that? Sorry?
Draw straws.
Yeah, something like that. We certainly hope that all members will take advantage of the opportunity for training over the next couple of years. It's just we may need to meter that out a little bit.
So I did just quickly reference the OCA website, and they do have the conferences up now.
Oh,
So it's June 4th to 7th in Niagara Falls, and that's the spring conference. And then there would be a fall conference as well, which is October 12th to 13th at the Holiday Inn Toronto Airport. So I want to correct what I said earlier. Typically, the city would send staff and or members to that spring session held in June, or I guess the summer. So we will certainly get more information on that, and then we will circulate perhaps by email to members if anyone is interested or available. And then we will go to our director for budget and see what we can do there.
Can we put that on then for an agenda item for the next meeting?
March, absolutely. Yeah, we'll try and get an email out to everyone in advance of that as well, because it does look like they have hotel information up here as well and how to register.
Okay, thank you. All right, so I should have said, I do have a couple of additions to the old business that we can talk about after we do the Property Standards Committee training.
Well, I was really hopeful to have more information as of this afternoon for you on the training. We have made a request to the Ontario Property Standards Association, who they are able to provide you with some online training. I've heard that it's a 4-hour course. They are able to accommodate us via Zoom, and the request has been made for us to hold that sometime before our March 28th appeal hearing, which we have set. So notice of that appeal will be going out this week. So members will receive that as well in an email and on SharePoint. But staff really do hope to have some training for you in advance of that appeal hearing. Unfortunately, we're in a waiting pattern right now with that association. So as soon as I hear, I will let the committee know.
Okay, and on that, just emails about whether or not they should be Zoom meetings or in person.
I can speak to that. Yes. So at the sorry to cut you off, Madam Chair, at the recommendation of the city clerk, we did go to the appellant to see if they preferred to have their appeal hearing in person or virtually. That's how it is done in court. And the appellant did come back to us this afternoon to say they wish to have the appeal hearing in person. So our March 28th appeal hearing will be in person. We can look at it as a nice opportunity for PAC to once again meet each other in person. It will be held here at the Operations Center, and it will be at 6 o'clock at night. So again, we did just receive confirmation of that today, but notice of that hearing will go out to all members this week. But please do plan on attending in person.
Thank you. Anybody have anything to comment on that? Oh. All right. So I had on their ID. Oh, sorry, Carrick.
It's okay. Thank you. I just got back from vacation, and I had not got back to Albert yet, but I will be available to attend that 28th meeting. So. Thank you.
So just following up on ID badges.
Yes, we did hear from the city clerk today, who is away from the office. It was just on her to-do list, and it will be forthcoming in the weeks ahead. Additionally, we did ask about the FOI training that the city clerk did identify would be happening when she met with us at our December 6th orientation training. And the idea there was that all members or all committees of council would go on an online training session with our city solicitor to learn about freedom of information. And I think we just haven't had the opportunity to schedule that yet, both with the solicitor and to accommodate all committees of council. So I do understand there are some vacancies on a few committees still. And so I think we're just waiting to fill those vacancies before we secure that.
And that would be the same then for the conflict of interest. Is that right?
Sorry, My apologies. That is exactly what we're talking about, the conflict of interest, not freedom of information, which does
About-
apply, but it's not the training that we're sending you for. It's conflict of interest.
Right. Okay, so does anybody have any comments or anything before we close the meeting? Feeling comfortable? More comfortable? Yeah, that's good. Okay, all right, well, thanks, everybody, and I also want to echo, everybody's been so helpful, Albrecht and Melissa and Kevin, thanks. Thanks for helping us out.
Great job, Tara.
All righty, so we need to close the meeting. Who would like to move that? Carrick. All right, thanks, Carrick.
Thanks, 10:09.
All right, thank you very much. Good night.
Enjoy your evening. Thank you.
And everyone.
Good night. Thanks, everyone.
Good night, everyone.